Remember, Deya just arrived in the country this morning at around 4:30. Not much is expected from the court. It's the first hearing. Probably there will be a bail application. I'll try and understand that from Sekou Owino. Probably there are issues that have not been brought to the attention of both the prosecution and the defense side. We'll try and make sense from Leila, who is in court. But let me bring this discussion back here, and we'll also be playing the earlier pictures when he came into the country. Right on your screen, he arrived in the country at 4:30 a.m. This was after he was deported. This week, there was a final decision to deport Deya, who has been fighting the extradition case from 2007. And the first time they attempted to deport him was 2004. In 2007, it was determined that he'd exhausted all avenues for blocking his extradition. And in 2011, Theresa May, who was then the Interior Minister in the UK, decided that finally they will deport him. But he managed to stay on in the UK for additional 6 years, and finally they deported. And Sekou Owino, who's here, was just explaining to us how that has to happen. So there must be an agreement between countries, and the crimes must be seen as both by the laws of those countries. Both the countries. Yes. So if that was not the case, he would have not been extradited on this case of kidnapping and child trafficking.
Yes.
All right.
It means if the UK did not recognize the offense of kidnapping and child trafficking, then they would have no basis to extradite him.
Okay.
So this has happened before in cases where one country makes a request for extradition, and the other country looks at it and says, this is not an offense under our law. It often tends to happen in political cases, particularly people who are considered to be freedom fighters. So one country wants to charge you with, say, treason, but the other country looks at it and says, no, this is a person fighting for independence. We do not think this is a fair charge. We do not recognize it under our law. And therefore, they are
so they'll actually protect you.
Yes.
The reasons that Deya has been giving all these years, Sekou,
yes,
is a breach of his human rights.
Yes.
And he says he will be tortured and subjected to inhumane and degrading treatment.
Yes.
Well, this valid concern, looking at the jurisdiction Kenya, do you think this is a valid concern or just points that they were putting there just to beef up their case against extradition?
The court eventually overruled him on those and said that, look, we do not see that what you are alleging necessarily occur, because he was alleging that these charges were being brought against him on account of political persecution. And the courts held that having investigated them, they did not see substance in it. They also held in the final decision before the order was made is that, look, Kenya has given us the guarantee that you will be accorded your constitutional rights. The Constitution of Kenya has an elaborate Bill of Rights, which also has very, very protective right to fair trial for a person, and therefore they held that his complaints were unwarranted in law.
But how did he manage for 10 years?
It's because, that's the reason I'm explaining that is because countries have to be careful for that purpose. Okay. Especially if somebody is saying that the reason these charges are being brought is so that I'm persecuted. They themselves have to conduct some investigation. So in the process it gets delayed, and you're given the opportunity to challenge every decision made and to raise all factors so that a person is extradited if the court, the country that is conducting the extradition, the responding country, Kenya in this case was the requesting country, the UK was the responding country that is extraditing, they have to be sure that there really is nothing other than a fair request for true prosecution, other than for any other purpose. Basically a rule of law question. They have to satisfy themselves. Is this really, really pursuant to a pure rule of law question rather than persecution or any other motive behind it?
And I guess a lot of people are asking this morning, Sekou, for 10 years, why didn't the UK try this man? Why didn't they try him? Because they're looking at it like, if at all you stole the babies, you brought them to the UK and passed them on as miracle babies. Why couldn't they try him?
Yeah, because those offenses were not committed in Kenya.
In the UK.
You know, you can only try. Very few offenses can be tried by a country if those offenses have not been committed against them and if they are not committed by a citizen.
Regardless if the people, the residents of the United Kingdom received the babies, because you remember during the trial there was DNA testing and everything, and they said that the reason why the DNA is not matching is because they're miracle babies, you know?
Yes. So what the court has to say is that where is the best possible place for this thing to be tried?
Okay.
It is in Kenya, because that is where the offenses actually were committed. The theft occurred in Kenya. if those were Kenyan children, as Kenya was alleging. So then they were told, okay, this is the reason why it's best conducted. A case is tried where, at the locus where it is best able to, the group of contacts, as they call it in international law, where is the greatest of the factors that would influence the decision in that case occur. In this case is Kenya. Okay. Because the complainants, for somebody to say children were stolen, the complainants would have to be people in Kenya and that kind of thing. So they said, okay, just guaranteeing him his fair rights to be tried fairly, then go and try the case in Kenya.
99, 2017, almost 20 years.
Yes.
Why are we still trying cases that happened almost 20 years ago?
Because, you know, Ken, as you know, people need to understand that in criminal law, there's no limitation to crime. Okay, if as opposed to ordinary civil cases which have a limitation, crime has no limitation. So a person can actually be tried for an offense that he committed. As you probably see, last year there was somebody tried in Germany for an offense he committed during the Second World War, essentially for a war crime. He was now almost 90 years old. These are offenses he committed 70 years ago. Whoa. And they're told there is no limitation. So if you ever commit an offense, as and when the evidence becomes available, you can be committed, you can be tried.
Okay.
So even within Kenya, just to give an example, the only crime that, there are only two crimes that would have limitation. There's a crime of treason, where there's a limitation of 2 years. If you're to charge somebody with a treasonable act, it must
happen within 2 years.
Yes, because that too is because it's a political crime. They're trying to close the window for it for purposes of evidence. But any other crime, that's why. So I think as soon as the evidence becomes available, you can be tried.
And as we move away from the explanation behind extradition, I just want to bring a new element to it. Yes. There is an extradition case that has also been fought for close to 7 years, Christo Kemo Samuel Gishuru case. Yes. And judges have an agreement with Kenya. Yes. It's also taking too long. Perhaps we've settled one, but there's one that is still ticking, especially for Kenyans. It's an economic crime. Talk to us about that, then we can move on and discuss another element of this case.
Same thing, yes, because of the same thing again. Again, before Kenya extradites, you have to be sure that all those protections that are meant, but there's an international convention on extradition.
Okay.
So you have to make sure that this person is granted the fullest protection and that before he's sent to another country for prosecution, you have exhausted all the rights that he could have been entitled to.
Okay.
And that there is no reason for that other than the simple rule of law question of going to be...
Exhausting all the rights. In 2011, Theresa May, then Interior Minister, said that he has exhausted and there is no further reason to have him in the UK, but he still remained there for 6 more years.
Yes, yeah. Because after that, he now raised, you know, originally there are 2 steps. There are the administrative questions and then the legal questions. And at that time, when she made the decision that there are no other basis, she said all the excuses he had given were not justifiable. Then she ordered that he be extradited. Then he now challenged this on account of human rights questions. That's when he now started saying...
So that's when the trial on human rights began.
So the human rights questions came back again. And the judges eventually looked at it and said, these issues have been raised before. You're just giving them the guise of European Convention on Human Rights guise. So they again overruled him.
I don't know how this case is going to pan out or turn out to be at the High Court right here in Nairobi. We have seen Cliff Ombeta, a reputable lawyer, criminal lawyer, and other lawyers. In fact, it's a battery of lawyers dealing with the Deya case. But I want to take you back to Deya's wife and how fast her case was concluded. She served some years right now at, I think it's at the Langata Women's. The fact that they were jointly to be tried in this case.
Yes.
What if new elements are introduced that were not considered at that time when they were trying the wife?
Yeah, these now will be
totally
2 different cases.
Totally
the evidence has to be provided afresh. The trial has to be...
But can they use the fact that they found the wife guilty?
No.
They cannot bring it.
Guilt is individual. Guilt is individual.
But it was jointly committed with...
No, that's an allegation. Even if you charge 2 people with committing an offense, for purposes of conviction, you have to prove the guilt of each and every one of them.
Individual.
Which is why sometimes several people can be charged, some will be convicted, and others will be acquitted.
Others will be given lighter sentences, others will be given very heavy sentences. So we have to divorce these two cases entirely.
Yes.
All right, let's come back to the case. It's begun at the High Court.
Yes.
And what do we expect going forward? What do we expect today? He's just come back in the country. Yes. I think this has been going on for a long time. There are quite sufficient investigations. And remember, there are complainants in this case. Yes. If these women don't turn up in court to complain, in this case, what happens? Is it still state versus?
Yes, it's state versus him. The state prosecutes it, but the complainants provide the evidence.
If they don't?
It's been a while. If they don't, it would be unfortunate, because then he would have to be, not unfortunate, his constitutional rights would have to be upheld. He would have to be acquitted. So you hope that he will be tried, granted a fair trial. All the evidence that the prosecution has marshaled will be brought in to bear into the case. The judicial officer will consider it. He will be given the opportunity to cross-examine them, to clarify and to challenge the evidence. And then he himself, if he's put on his defense, will give his side of the story and his evidence, and then a decision is made as to his guilt or otherwise.
This is a case that is very difficult to talk about, because then we border being prejudicial. But I'm just wondering, a lot of people right now looking at this trial and looking at 17 years that have lapsed. For other children, probably it's about 13 years. The other ones are about 17, 18 years. Looking at that period, the end game is what happens to these children. And I'm treading carefully because of being prejudicial on this. What is the end game for this case? Looking at these children stolen as babies, they're already grown-ups. They're teenagers right now.
Yeah, that would be difficult. It will depend also on how the conviction goes. I mean, how the trial itself goes. Because if it is not proven, for instance, and he's acquitted, then the situation will be, he didn't commit the offenses, let the children be wherever they are. Now, if he is convicted, then there might not be now the subsequent question as to the custody of these children. Where are they, and can they be brought back to their families? So this, that's something that has to be navigated here. It is a serious concern, because it will have a lot of repercussions after this trial ends.
And then that will open a Pandora's box, because then we'll be looking at the rights of those children.
Yes.
You know, what is in their best interest and that. Yeah. It's a very interesting case. So going forward, the case has begun. We can see it on split screen. It's going on. We have the lawyers. We have just seen them come to court today. Do we expect a lot from court today?
No, I don't think we expect a lot from court today. Having been just extradited and come into the country, the first thing that the court will want to do is to ascertain his identity. That is this the right person who has been extradited? Confirm that. Then we'll be asked to take plea. The formal charging, the plea is the formal response to the charges, whether he admits them, in which case he pleads guilty, or he doesn't admit them, he pleads not guilty. After that, then the court records whatever it is, and the next decision will probably be decision to consider bail. His lawyers may apply for bail. And
could all that happen today?
Yes,
okay.
It could happen today. Yes.
So apply for bail?
They may make an application for bail, which the judicial officer could consider and rule on immediately, or perhaps say, let me take some time to think through it, and then deliver a decision probably sometime next week.
In which case, he remains in custody.
Yes.
He remains in custody,
yes, until in custody. He's under custody. Yes.
Until next week. Yes. But looking at all those possibilities and looking at Deya the man, you know, one of the things that the court is considering, that he deposits his travel documents, because he might be flight risk.
Yes.
He's both Kenya and UK citizen.
Yes.
So which documents do we deposit?
You deposit
on account of this crime, right?
On account of this crime,
yes,
he will be treated as Kenyan.
Yes, Kenyan. Okay.
And therefore, the documents he will be required to deposit will most likely be the Kenyan one. You know, a passport given by another country cannot be confiscated by another country.
Would
so that Kenya, for instance, cannot confiscate the
UK
passport. Yes,
but would they have considered to revoke it before he left, or that's against also his rights?
Yeah, that's still his right. And until he's convicted of a crime in this country, in Kenya, they still have to give him all his rights and presumption of innocence.
Okay.
So that will remain there. And it's one of the things, I think that's one of the larger issues that will arise, and which the court will have to think about in considering the bail application.
Okay.
If he is to be granted bail, under what conditions? Bearing in mind that he probably bears and holds the passport of a different country.
Okay. Talk to us about the bail application, the laws governing bail application. This is a case that denial of bail is highly unlikely, right?
Denial of bail, okay, first of all, let's start. Bail is a constitutional right for anybody. In fact, the Constitution says that every person who's been charged with an offense, irrespective of the nature of the offense, is entitled to bail as a matter of right and upon reasonable conditions.
Okay.
So the question here will be the reasonable conditions, and unless there's a compelling reason to deny bail. So the question here will be, what is the compelling reason to deny him bail if his bail application is opposed? And so those issues will have to be considered. Somebody may have to say, look, he's been in this country, we've had to bring him, he didn't present himself here voluntarily, he's had to be brought by extradition.
For 10 years.
He's been 7 years or 10 years, whatever the time frame is. Those are the kind of things whoever will be opposing his bail in the event that they choose to oppose it will likely raise. His lawyers, on the other hand, will be arguing, and justifiably so, that the Constitution grants bail. As he stands now, he's still innocent until proven guilty, so that presumption of innocence must come to bear on his behalf and in his favor, and therefore decide whether, leave it to the judicial officer to decide whether to grant bail, and if it is to be granted, upon what conditions.
Okay. And before we take a break, let's talk about where this case begins. Yes. Where will it likely begin? In terms of facts of this case, where is it likely to begin? Back in 1999 or 2004 when he began to fight his extradition?
No, for purposes of proving the offenses, they will have to begin with the 1999 when the issues first arose, when the babies were allegedly stolen. So that's probably where it is. But of course, there's no obligation or compulsion on the prosecutor to choose which witness to bring first.
Okay.
He can decide whichever order he wishes to arrange his case. All right.